The next case to come before the court is State versus Andric. Good morning.
Good morning, Your Honor. Please report.
I wanted to just ask you first, you know obviously that you have 15 minutes, but do you want to take time for rebuttal?
I'd like to reserve 3 minutes for rebuttal.
That would be fine. You go ahead and introduce yourself now. I apologize.
My name is Judy Jimenez, representing the appellant, Andric.
Thank you.
I'd like to talk about the ineffective assistance of counsel in this case, the assignment error. In this case, the trial counsel bolstering the opening statement and closing argument that to reveal to the jury that Mr. Andric uses heroin off and on. He smokes marijuana and had gone through the treatment, been on probation and currently on probation in Summit County for a case there for possession charge. This disclosure planted the idea in the jury's mind that Mr. Andric is an addict and that he's a repeated offender, that he cannot stop using heroin. This is different than, I know that trial counsel knew that Mr. Andric's admission of using heroin that morning was coming up. However, I think it's different when you view somebody's an addict or somebody's an occasional user. I think that the comments made by the trial counsel in here prejudice my client's how the jury views him. And this is not an enhanceable offense. This is a straight possession offense. There's no reason for Mr. Andric's prior conviction to come up in this case. And that I know it's very rare that a trial counsel will bring up voluntarily where his client or her client's prior conviction. This was certainly unusual, and it's out of the norm, outside range of the professionally competent assistant. I know the state's arguing this was a trial tactic. I disagree with that. They're arguing that this was a trial tactic because the trial counsel knew that admission will be shown, Mr. Andric's admission will be presented as evidence during the trial. However, in that case, there's no, I don't think there's any reason for the trial counsel to voluntarily say, hey, my client, there's an admission used that morning, and I don't know how he would mitigate that fact by saying my client is habitual user. By the way, he's in probation with the same possession charged in Summit County. And I think the state is arguing that the trial counsel brought that up because the fact that Mr. Andric is on probation in Summit County to say that he's being drug tested for that probation, that therefore he's not a current user. However, this trial counsel never brought in a probation officer as a witness to corroborate that. It didn't bring up any drug test results to corroborate that either. So I believe this is a clear case of ineffective assistance counsel. The second thing that why I say it's ineffective assistance counsel is that there was a jacket, chef's jacket, that was introduced as evidence. However, it was not introduced as a jacket. Only the picture of the jacket was introduced. I believe that's a violation of best evidence rule. The trial counsel should object to that evidence, that picture of the jacket coming into evidence in this case. Considering that the jacket was never shown and Ms. McCormick was not as a witness, the state didn't call Ms. McCormick at the trial to gauge her size, and I think that was a key piece of evidence, that the actual jacket is a key piece of evidence in this case, but this counsel failed to object to the jacket, the picture of the jacket being admitted as the evidence in this case.
But the officer testified that it's swappable.
Yes, Your Honor. I don't know. I guess it's not exact science. So nobody knows. They were approximating what her size is, how big it was. So if it was shown, witness being there, jacket was there, compare the size, it would have been better evidence.
So you're saying that counsel should have subpoenaed the witness and the jacket, and had the witness put the jacket on in front of the jury?
Absolutely. And then also that if not, objected to, that a picture of the jacket being as evidence.
The problem with that is, doesn't it go back to really to strategy? Because the problem with that is, in any number of cases I can think of, and I don't want to start talking about, no, I'm not going to start talking about that, but you have in front of the jury this little diminutive woman with this jacket just hanging down to her ankles, so sometimes there's a reason for that, isn't there?
I agree, but I don't know what happened in this case, but that it could be trial tactic. However, he should definitely object to if that's the case, that jacket.
I know the answer, I guess, is what I'm saying. Don't do it.
Yes, that's correct. Another point that I want to make is that during the closing argument, the prosecutor stated that the defendant is not required to present any evidence. But ladies and gentlemen, I guess the person who would be able to testify, Sarah, whatever her name is, Sarah McCormick, and you have heard no testimony from her that it was hers. The only testimony was that you have here is that it does not fit. This statement shifts the burden of proof to the defendant. That the prosecutor said that it seems to insinuate that it was on the defendant to bring Ms. McCormick in to prove that that was her jacket, or it's not her jacket, whatever the case may be. That simply the state cannot do that, shift that burden to the defendant, and the trial counsel failed to object to their statement. Another assignment error that I pointed out is the sufficiency and the manifest weight of evidence. Mr. Andric was indicted and convicted of 2 counts, possession of heroin and possession of cocaine. I know that this is not a regular constructive possession where there's a vehicle and the substance was found in the center console or out in the open. This was a case where the substance was found in a specific pocket of a jacket that someone owned. This is not, and the jacket is not something that is personal. It is not my pink jacket. It's a chef jacket and it's a part of the uniform. I understand that Mr. Andric admitted to using heroin that morning. However, the issue is here that whether, as trial counsel correctly points out, that the issue is here is whether the contraband that was found in the jacket pocket of that it is the whether Mr. Andric knowingly possessed that contraband. I know that possession is different than ownership. However, in this case, there is no reason to believe a person who's looking into the car, who's just passenger in the car, will know that with someone other than the person who owns the jacket knows about the things that's in the pocket. Only evidence that was presented regarding the jacket is the police testimony that the jacket did not fit on the passenger. There was no evidence showing that that it does or does not fit Mr. Andric. There was no size comparison from the record saying that Mr. Andric is, 6'5", and this jacket. There's no evidence that it is Mr. Andric's. Only thing that's presented is that there's this jacket. It doesn't fit the passenger. Therefore, it must be Mr. Andric's.
Excuse me, I just don't remember all the facts. The jacket was an exhibit at the trial.
It was a picture of the jacket was exhibited during the trial, and the actual jacket was never shown.
Was there anything in the picture from which you could infer the relative size of the jacket, or was it just a picture of the jacket with a solid background?
It was a picture of the jacket. I do believe it was a picture of the jacket.
We can check the record.
Right. I think it was on the trunk of the vehicle.
Okay, thank you.
So there's absolutely no indication that to say was Mr. Andric who owns the jacket.
Does Mr. Andric own the car?
Yes, it was registered to Mr. Andric. It was his vehicle. And also, I understand that amount of the contraband does not matter when you're talking about whether you have the substance or do not have the substance, and I think that's the current state of law, case law. However, you do have to prove, the state has to prove beyond reasonable doubt that Mr. Andric had knowledge that he possessed, he has the substance. I'm presenting to this board that the state did not produce evidence beyond reasonable doubt that Mr. Andric knew about the contraband that was in the jacket pocket.
And counsel, you're in your rebuttal time if you want to say that.
Thank you.
Thank you. You may begin, I'm sorry.
Thank you. Good morning again, Your Honors. My name is Matt Kern on behalf of Dean Holman, Medina County Prosecuting Attorney. I represent the state of Ohio in this matter. I guess I'll take the assignments of error in the order of the brief because I want to save most of my time for the ineffective assistance portion. So on the sufficiency and manifest weight issues, the evidence at trial established that the consent search of the vehicle done, during which they found this chef jacket. The vehicle belonged to Mr. Andric. The passenger, Mr. McCormick, the officer testified was 4'8", 100 pounds. They had the jacket, they had her try the jacket on at the scene. It was loose fitting, it was huge on her. The quote that the officer used at trial was, "It hung off of her like a dress." She's 4'8". Mr. Andric is taller than she is. The jacket does not fit her. It's in his vehicle. It's registered to him. He, during the pursuit, when the officer was chasing him from the shoplifting event at the Wadsworth Walmart, was reaching into the back seat of the vehicle in the area where the jacket was found. He admitted during questioning to by the officer that he had used heroin earlier that day, and in the jacket they find the device, the needle with residue and additional powder. So the jacket was clearly being possessed by somebody in the vehicle, and the evidence showed that Ms. McCormick, that it was likely not her jacket. It's in Mr. Andric's car. The jacket more likely fits him. So that leaves only the defendant, who admits that he has previously used drugs that day, consistent with what they find in the needle in the jacket. So the evidence was sufficient for a reasonable trier of fact to find beyond reasonable doubt that the defendant knowingly possessed the substances. If I could move on to the ineffective assistance portion. First, I'll note that the best evidence argument raised today was not raised on brief. It's raised for the first time in oral argument today, so the court should decline to consider that. Even so, the best evidence rule also addresses under 1002 that duplicates or copies of the thing, as long as they are true and accurate duplicates, are admissible as an original. So the best evidence argument would also lack merit. But it's made for the first time, so you should decline to consider it. With respect to, my understanding is there are 3 subclaims for the assignment of error. The first is telling the jury about the defendant's previous drug conviction. Now, in State v. Johnson, out of this county in 2014 Ohio 62, this court said in paragraph 27 that it can be strategic to tell the jury about a defendant's prior conviction. In that case, it was part of the self-defense claim. Now, it ultimately lacked merit, but the court found that it was strategic. Part of the tactic in this case was essentially to ask for nullification by telling the jury about the defendant's experience in the Balkan Civil War and his immigration to the United States by essentially asylum, leading to his experience.
The only problem with that is, should we condone jury nullification? Should
No.
we say that's a valuable strategic defense?
Well, no, you shouldn't. But,
Yeah, that's what my concern is, I guess.
but in this case, there's 2 parts of it. One is when the evidence is found in such a way that really your only viable hope in the case if the defendant is not willing to accept a resolution before trial. In Medina County, we have a no deals on drug cases policy. I think that's well known. Unless you are willing to admit to the charge, we are going to trial. So in this case, with the defendant insists on a trial, and you're tasked as defense counsel with trying to present a defense, what's left? Essentially, you're hoping for some kind of nullification, and you have to give the jury something to hang their hat on as a defense attorney. What is that in this case? The knowing possession argument is pretty thoroughly deflated by the fact that officers on the scene asked the passenger to try the jacket on, and it clearly does not fit her. That testimony is undisputed. Having her come in to testify and potentially try the jacket on is only going to further show that the jacket does not fit her. In fact, not calling her was probably more strategic than the other alternative. If I'm a defense attorney and I want Ms. McCormick to come in and testify and I want her to try the jacket on, there's only a chance that the jacket is going to hang off of her like a dress and further show that it's not hers. The argument at trial that the defense counsel made, in closing specifically, that was not supported by any evidence whatsoever, was that Ms. McCormick worked as a chef. There's only a chance if you call her that she's going to testify, no, that's not true. Or Mr. Andric works with me and that's his jacket. That's the chance. So it's strategic not to call her. But telling the jury about the defendant's prior drug conviction was part of the decision to talk about the defendant's post-traumatic stress disorder, how he resorted to drug abuse as a way to cope with that, and that as part of that conviction, as part of his probation for that, he was on drug screening for which he was testing negative. Now, there's no evidence of that, potentially because it's arguably not true. I don't know, it's not part of the record. But there's only a chance that the defense counsel didn't present further evidence of that because, well, his client tells him, hey, I'm on probation, I'm testing clean. Fantastic, let's tell the jury that because you're in possession of these substances, you know you shouldn't be, you told the police you've used drugs earlier that day. I need some kind of explanation to tell the jury why they shouldn't convict you in this case. Well, what I'm ultimately building towards is if the defendant's already admitted using drugs that day, doesn't that make the fact that he knowingly possessed the substance that much more likely? Yes, it does. That is an inescapable, clearly relevant conclusion. What prejudice does the defendant suffer from counsel making this strategic disclosure to the jury? It humanizes him. Yes, he has a problem, but he's dealing with it. That, therefore, these substances probably weren't his. He had already used that morning. Why did he need more? right? That why did he think that there was anything left in there? These are all arguments now available to the defense counsel in closing once that disclosure is made. Arguably, it's a strategic disclosure. Even if the court finds that it's not, however, and this is a separate conclusion that if you make, you wouldn't need to get to the deficiency argument, what's the prejudice? The defendant, it's his vehicle, the jacket's in the vehicle, it doesn't fit the passenger, somebody's clearly possessing it at that time, and the defendant has made a prior disclosure to the officer that day, that it seemed that previous to that day he had consumed, ingested an illegal drug, which they find in the jacket. He's going to get convicted anyways. The outcome here is not cast into any doubt because of this disclosure. The jury would have convicted him anyways. Second claim, as I understand it in this case, is about failing to object to the BCI report. Now, the BCI report was brought in through the officer's testimony because there was no demand for the live testimony of the analyst made in this case. Right? The notice and demand statute 292551A clearly states that if notice is given for the BCI report that's potential admissibility, which it was in this case, failure to demand the live testimony results in it being admissible. No demand was made for the testimony of the analyst. The report was therefore admissible. So it's not hearsay. It's a business record of BCI under 8036, as the 5th District has held. The Ohio Supreme Court has held that coroner's reports are admissible as business records in State v. Maxwell. So the only thing really left on this subclaim is about not objecting or not demanding the live testimony of the analyst. And as the 3rd District in State v. Urbina said, it can actually be very strategic to not demand the testimony of the analyst. In fact, you hope the state does not call the analyst, because all the analyst is going to do when they testify is impress the jury with their impressive credentials, their master's or doctorate degrees, their extensive training, their experience in the lab, and convince the jury that this is in fact the substance. And now, instead of talking about whether a defendant knowingly possessed a substance, you're focusing on whether the state proved that something is a substance. No, that's not strategic. You want the jury focused on the knowingly aspect of these cases. That is where the potential weakness lies. Sure. You don't want them focused on whether the state proved a relatively easy element in terms of the scientific advance. So, State v. Arena does that analysis. It is strategic not to demand the testimony of an analyst in a case where you want to challenge the defendant's mental state. So, the BCI report was admissible, 292551. The notice and demand statute is clearly constitutional, as the U.S. Supreme Court has held, and as the Ohio Supreme Court has affirmed. That was a strategic decision in this case. The last subclaim, as I understand it, is about the failure to object to this closing argument. Now, I know Ms. Kim Reynolds has read some of that argument to you already, but the part that she's missing this morning is what defense counsel said in their closing argument. Defense counsel, closing argument, was talking about Sarah McCormick, and it's her jacket, and we know that, it's blah, blah, blah. But that argument wasn't based on any other evidence. That argument was just a mere base conclusion. The state responded by pointing out that nothing in the record, or nothing at trial, supported defense counsel's argument. In fact, above that paragraph in the state's closing argument, the state said, you see whether or not they're supported by the evidence. He keeps saying that's the girlfriend's things for work or a shirt for work. All of the evidence points that it's not hers because it doesn't fit. The defendant's not required to present any evidence, ladies and gentlemen. I guess the person who would be able to testify is Sarah, whatever her name is, Sarah McCormick. And you've heard no testimony from her that that was hers. The only testimony you've heard is that it doesn't fit. The state was specifically responding to defense counsel's argument that the jacket was Sarah McCormick's. He did that by pointing out that the evidence showed that it didn't fit her when the officers had her try it on at the scene, and by pointing out that there was no other testimony by the defense to show why that argument should be believed.
In a way, though, it kind of makes it worse when he says, though, the defendant doesn't have any burden here. And so that's almost like code. Well, we know he doesn't really have any burden, wink, wink, but boy, if you knew that that was your girlfriend's jacket, why does she come in and testify? Why did he prove it's not?
Well, I guess I strongly disagree with the whole insinuation point.
Suggesting you shouldn't, but...
Well, but even more so, the Ohio Supreme Court has specifically held that when there are specific references to items or evidence or testimony that's never introduced, the prosecutor can point out that the evidence is uncontradicted. That's State versus Alen, 98 Ohio State 3rd, 44, 2002.
There's a big difference, though, between saying it's uncontradicted. Go ahead, I'm sorry.
That's a fantastic point. As I said, the U.S. Supreme Court has held similar in U.S. versus Robinson. And the Ohio Supreme Court in State versus Williams, 23 Ohio State 3rd, 116 at page 20 in 1986, held that it's not improper to point out the lack of evidence supporting a defense theory, which I think is exactly what happened in this case. The defense presented an argument. The state responded that there's nothing that supports that. There's nothing improper about that. So there's no basis for the defendant's potential objection to that closing argument. So counsel was not ineffective for failing to lodge that. In fact, the quote from Williams is that the state is, quote, not prevented from commenting upon the failure of the defense to offer evidence in support of its case, period. There is nothing improper about the state pointing out the lack of defense evidence when the defense makes an affirmative argument that is unsupported by the evidence. So the state can get up to in front of a jury and say, ladies and gentlemen, they've argued X. They did not present to you any evidence of X. There is no evidence in this trial that supports X. That is not improper. The state has that ability because, as the U.S. Supreme Court has held, it is the right of both parties to meet fairly the arguments and evidence of each side. If the defendant, in this case, is a great example, if the defendant in a case, if the counsel gets up and says, defense counsel to a jury, this is not his jacket, it's her jacket, and we know that because she works at some Akron hotel and works in the kitchen. Except there's no testimony that she works in an Akron hotel, there's no testimony she works in the kitchen, there's no testimony that they're seeing each other romantically. There's no evidence of any of that. The state is not able to get up in front of the jury and say, ladies and gentlemen, the defense doesn't have an obligation to present to you evidence or to rebut the state's case. It's our burden to prove, and we accept that burden willingly and freely. We embrace that burden, but there's no evidence of that. In fact, the person you would expect to hear that from, Sarah McCormick, you didn't hear her testify. She doesn't say that. There's no evidence of that in this case. There's nothing improper about that. State versus Williams and State versus Notling, that the state has the ability to make those response arguments. And the other thing I would point out here is that there's no argument about prejudice for any of these subclaims for ineffective assistance of counsel. They're not argued on brief, and they're not argued today at oral argument. How any of these would have made a difference or affected the ultimate outcome of the trial is not developed, articulated, or established. The jury would have heard that the defendant used heroin that morning anyways. They would have, if a demand for testimony from the live analyst had been made, the analyst would have testified. That's not a problem. The report was admissible absent that demand, 2551, and the evidence at trial, specifically Officer Shong, testified in tremendous detail that the jacket simply did not fit Ms. McCormick. She's 4'8", 100 pounds. The jacket hung off of her, quote, like a dress. It is reasonable to infer that the outcome of this case would not have been different but for the challenged actions of defense counsel. Defense counsel was put in an impossible spot. This is
And you're out of time.
an overwhelming case, and I respectfully ask the court to affirm. Thank you.
Thank you.
About the prosecutor's closing argument regarding Alen McCormick not being there, if the prosecutor does not think it was proper for defense counsel to mention that Sarah McCormick works at a restaurant, proper way of handling would have been to object to that statement and strike that statement. This is not, what the prosecutor in this case stated is not just pointing out lack of evidence by defense. He specifically pointed out that why did the defense put this particular person on the stand as a witness to clarify all this. This is not just simply saying that there is no evidence shown by defense. That specific comment insinuates that it's defense's burden that to prove the jacket was Ms. McCormick's or was not McCormick's. That is not.
How have you been prejudiced by that? Because he did admit to using heroin that morning. He was reaching around to the back, if you believe everything that the officer said, which obviously the jury must have here.
I see that jury believing that, oh, why didn't he put a girlfriend on the scene if what you were saying the truth? And therefore, if you didn't put somebody on your behalf, somebody was close to you as a girlfriend, then whatever the officer saying, whatever the officer observed, it must be true. It gives more credence, more credibility to the officer's observation in this case.
But the jury is charged repeatedly that the defendant has no burden.
I understand that, but once that statement is out, it's hard to get that out of the jury's mind. The movement that the officer observed reaching behind Mr. Andric, reaching behind the passenger's side, back passenger side, there could be any number of reasons. I don't know if I get pulled over by a police officer, I immediately look for my wallet, my ID. It could be any number of reasons why he's reaching behind there. You cannot just conclude that he was trying to hide something or check something.
But isn't that a reasonable inference considering that drugs were found in that?
There was absolutely no evidence that he reached particularly for the jacket or the syringe or things that's in the pocket of the jacket.
And counsel, you're out of time.
Thank you.
Thank you. Thank you both for your presentations to the court. The court will take the matter under advisement and will send you a written opinion, and you can check on the website. Thank